see that we're recording on YouTube. We are now streaming. Good morning. Welcome to the First District Court of Appeals. We have 3 cases on our docket to be argued this morning. The first case is State versus Hall. Ms. Nelson is here on behalf of the appellant. Mr. Foreman is here on behalf of appellee. Ms. Nelson, you will have 15 minutes to argue. Would you like to reserve any of that time for rebuttal?
Yes, I'd like to reserve 5 minutes, please.
All right, and whenever you're ready, you may begin.
Thank you. May it please the court, and good morning, opposing counsel. Sarah Nelson again here on behalf of the appellant, Mark Gabriel Hall. This morning, I intend to only focus on the first assignment of error regarding the issue of witness non-disclosure. This court should reverse and remand Ms. Hall's case for a new trial, as Ms. Hall was prejudiced by the state and the trial court having failed to honor the rules of discovery regarding the non-disclosure of witnesses. Now, admittedly, the case law in this area typically finds no prejudice to the defendant when witness names are disclosed, but this is actually a unique case where the rules of non-disclosure were not followed from the outset and warrant reversal. Ms. Hall was precluded from the ability to investigate the credibility of an essential eyewitness, and based on the rule violation, was not afforded an opportunity to have the state's basis for non-disclosure adequately vetted under the proper procedure. Criminal Rule 16D dictates that the state must certify to the trial court its basis for not disclosing certain information. That certification in this case came by way of a supplemental discovery response. That is not the type of certification that is contemplated by the rule, but not only that, even though it was improper, defense counsel still filed a motion in opposition to this assertion.
So counsel filed a motion, but they never had it set for a hearing? Is that what happened?
There was a request for a hearing in the motion, but you're correct, a hearing was never actually established.
So then the hearing just happened on the day of the trial, right?
Yes, which is in violation of Criminal Rule 16F. The hearing is supposed to occur 7 days prior to trial, and that onus is on the trial court. Once the defendant files a motion in opposition, the burden then is on the trial court to hold this hearing. And under the case law, the trial court is actually supposed to outsource that hearing to a different judge. So in this case—
But if the motion is filed and defense counsel knows that it hasn't been set for hearing, isn't there an obligation on defense counsel to make sure that it is set for hearing? Or maybe the court presumes that the request has been abandoned.
Well, I'm with you on that, Judge Myers, but I think there's dual obligations here. Defense counsel's obligation is to file the motion in opposition, and under Crim Rule 7F, it says the trial court shall hold this hearing. Now, whose specific responsibility is it to actually set that hearing? I would put that onus on the trial court in this case, specifically because it has to be rolled to a different judge. So
if the trial court knows it exists.
Which goes back to, go ahead.
Unfortunately, I think human error, and maybe particularly in the time of the pandemic, may mean it fell through the cracks at some point in time and the trial court didn't know it hadn't been set. Possible in this case?
Possible, and I would relate that harm back to the fact that the state didn't file a proper certification for non-disclosure. But again, the defendant tried to remedy this harm by filing its motion in opposition, knowing that the state's basis was wholly inadequate, challenging that the state needed to put on whatever evidence it was relying on for its basis of witness intimidation and coercion. And again, the trial court, there was no effort to move this along to the mandatory 7-day hearing, 7 days prior to trial.
So what happens in that? I mean, so they didn't do the 7 days. I mean, clearly you agree there was a hearing on the day of trial. Is this like automatic reversal because the trial court didn't have a hearing 7 days before trial?
Yes, I think that should be the result in this case, particularly because of the sensitive issue of eyewitness identification and the fact that the state's basis for non-disclosure was to preclude defense investigators from investigating this witness.
Didn't the trial court— Go ahead, Judge Bach.
I think we're probably going to ask the same question, Judge Myers. Didn't the trial court offer the opportunity for continuance?
The trial court did not. They said that the defense counsel could interview the witness prior to trial, but it's our position that that's an inadequate remedy under the circumstances of this case. And I believe the record suggests that the trial court would have been reluctant to afford any continuance because of the unique nature of this case being the first jury trial setting since the COVID shutdown.
Why was that an inadequate remedy? Isn't that the remedy that you would have wanted 7 days earlier?
At least there was a time, a week, to adequately vet and investigate this witness. 1 day does not provide sufficient opportunity to interview, investigate, and vet for credibility purposes an eyewitness. And
maybe not, but we don't know that because the opportunity that was afforded wasn't taken advantage of.
I agree with you. In contrast, the case law where the names are revealed for the non-disclosed witnesses, there is tremendously more time. So in certain instances, there have been no prejudice to the defendant when names are revealed at a jury trial setting, but then the case for whatever reason gets continued and then the case resumes about 6 months to a year later. That's not the type of case that we have. We have a 1 day in the midst of a jury trial where defense counsel is supposed to stop, drop, and interview a witness prior to the start of trial. I think that that's an inadequate remedy under the circumstances of this case.
But let me go back to something you mentioned early on, and that is that the name of the witness was disclosed from day one. Are you saying that that defense counsel was unable to figure out who that was?
Yes, there was conflicting information in the record. So as the state points out in the CAD report that was provided in discovery, her name there's 2 different spellings of her name. And as the state points out, she was reluctant to even answer phone calls from the prosecutor. So even though some of her contact information was available, it didn't appear to be beneficial.
So her cell phone was available.
Correct. But
did defense counsel or their investigator, is there any indication in the record that they attempted to call that number and she wouldn't respond?
No, there's no indication in the record. Although the Rule 16I that requires witness disclosure doesn't actually contemplate phone numbers, it specifically requires names and addresses. So despite the phone number being available, the address is still the issue in this case.
But we're trying to examine prejudice here.
I understand that. Yeah, I understand.
And so I'm just wondering if they would have tried the number, if they could have said, hey, she hung up on us or told us that she wouldn't talk to us, or I don't know.
That information certainly would make a clear record on the issue of prejudice for sure. But that's not what we have here. And what we do have, though, is complete circumvention of the criminal rules with respect to witness non-disclosure. And when it comes to eyewitness identification, I think these rules need to be strictly complied with to the best of the court's ability. And what should have happened in this case is upon notice that the motion was still outstanding, the trial court should have vacated the jury trial and held the 7-day hearing. It rolled it to a different judge.
Let me go back to Judge Bach's question. If that had been requested, I mean, there may be good reason why your client didn't want to request a continuance. Does the trial court have an obligation to continue at Suisponte if the defense doesn't want a continuance?
I would say the defendant raised its motion again, so suggesting that it did want the hearing that it requested. And it did cite in the motion the case law that supports that it has to be by a different judge, and the rules dictate that it needs to be within 7 days of the trial. So, I mean, we are in a tough spot here where the trial court is forced to choose, in a rock and a hard place. I concede that, but the rule mandates, it says shall hold a hearing 7 days prior to trial. And I think it's an abuse of discretion for the trial court to just avoid that mandate.
Counsel, the fact that trial counsel didn't cross-examine this witness, how does that play into whether your client was prejudiced?
I think that encapsulates the issue of prejudice in this case, that defense counsel was not able to adequately prepare an effective cross-examination, and rather than go rogue with no information, having not investigated this witness, elected to not. Now, again, that's a little speculative. I don't know the trial strategy basis, but the motion asserted that defense counsel would be precluded from adequately or sufficiently preparing a cross-examination, and to be sure, they elected to not cross-examine this witness.
And you have about 1 minute left.
I just want to reiterate that is an egregious abuse of discretion in this case for the trial court to have accepted the state's asserted basis that a defense investigator would interview this witness and cause intimidation and coercion. That is not what Criminal Rule 16D1 contemplates whatsoever. The case law suggests that that rule is reserved for the defendant or associates of the defendant contacting witnesses, not defense investigators. And this court should reverse to avoid that assertion from becoming precedent. And
can I quickly ask you, because you're basically saying that because the trial court didn't hold the hearing 7 days before trial, that it requires an automatic reversal because the rule says shall. Do you have cases that support that?
Not that specific basis, but that's just one of 3 harms with respect to applying the rule that I'm trying to articulate to this court. The failure to hold a hearing, the fact that the state did not put on a proper certification request, and that the fact that their request for non-disclosure was not only wholly inadequate, but offensive to the notion of a fair process by saying a defense investigator should not be allowed to investigate an eyewitness in this case. So for those 3 reasons.
I'm sorry, this time won't be counted towards your time, but that led me to a follow-up question. Assume we agree with you on all those points. As Judge Krause pointed out earlier, don't we still need to look at whether there was prejudice? And if there was no attempt to interview the witness, no request for a continuance, no affirmative steps taken by defense counsel to protect their client at that point, what are we to do with that in terms of prejudice?
I think the prejudice issue needs to bounce in Ms. Hall's favor under the facts of this case because of the blatant violation of the rules. And I understand that that's a hard position to take because of the reasons that you just cited, Judge Myers, what defense counsel could have done to mitigate the harm of this. But really the harm in this case stems directly from the failure to follow the mandates of the criminal rules. And the unique nature of these rules put the onus on the state and the trial court to ensure that the non-disclosure is being properly vetted. And Ms. Hall is harmed by the failure to properly vet this information. And we could be in a situation where none of this is moot if there had been a proper hearing in certain respects. So that's where the prejudice stems from, is from the blatant violation of the rules, the procedure not being followed, and then the harm that results from not being able to interview eyewitnesses when eyewitness information does not, it changes every single day. What we remember from yesterday will change day by day, and the longer you wait to interview an eyewitness, the less reliable that witness becomes. So with your permission, I'll just reserve the remainder of my time for rebuttal.
All right, thank you. And as I said, that will not count against your time. You will still have 5 minutes.
Thank you.
Mr. Foreman, you have 15 minutes.
Thank you. May it please the court, Ms. Nelson. The city of Cincinnati respectfully requests that you affirm the conviction because the defendant was, quite frankly, provided a very fair trial. Just to give you context, this was the first COVID municipal court jury trial because of all the restrictions. Having said that as a backdrop, Judge Kissinger exercised sound discretion in his rulings. Pursuant to 16L1 criminal rule, the trial court has discretion to make orders as it deems just under the circumstances. What's interesting is this isn't a sandbag situation. The state did not sandbag the defendant. In fact, twice in discovery, the CAD report, the computer aided dispatch report, which included the 911 calls, and the 911 calls were also disseminated and provided in discovery.
Sorry to interrupt, but you're jumping to prejudice. And I'm just wanting to ask, did the state violate Rule 16 by failing to disclose the address on the basis that they were concerned that the defense investigator would scare off the witness? Was that appropriate under the rule?
It was appropriate under the rules, and that's what Judge Kissinger found. And then he
why? But I mean, from my reading of the record, all somebody would have to do is say that they're afraid, and that's it. That doesn't seem sufficient.
Well, in this case, I agree on the strict scrutiny rule, if you would, the strict language. The address needs to be submitted. However, Based on the circumstances and based on the hearing, the court determined that that's a non-issue, simply because all of the hearing itself revealed that we acted appropriately. That's what the court found. So the hearing is to vet those issues, and we did have a hearing. What I find interesting is that this is an abuse of discretion standard. So even simply an error of law or judgment, it's more than that. So even if the court did make an error and say the prosecutor was appropriate in this circumstance, it's more than just simply an error of law or judgment. It has to be the court's attitude is unreasonable, arbitrary, or unconscionable. Here, the judge did give and suggest a continuance.
Yeah, but
Also,
that doesn't, I mean, I'm sorry to press you, but you're saying that there was not a violation of Rule 16. And if we agree with you, we would have to say, yes, it is appropriate for the state to withhold address information of a witness, not when they're afraid that the defendant or his associates are going to intimidate the witness, but because they're afraid that the defense investigator is somehow going to intimidate the witness. Now, certainly we can't say that, right?
well, my response would be pursuant to 16D1, we did have reasonable articulable grounds to address this non-disclosure, because under that rule, this may include but not limit to the nature of the case and any other relevant information. It's not limited to that. So the other relevant information was this witness was not going to cooperate. This witness, I used that same cell phone number to reach her, and it was late at night or early evening. We work long hours here at the city. So she was shaken, as well as the court found that this was an appropriate non-disclosure. So I would argue we do fit under the rules because it's any other relevant information, and the courts do have broad discretion over discovery matters. So we do fit under that provision.
What about the argument, at least in practice, that disinterested judge is the one who is supposed to conduct the hearing? Can you address that?
Trial counsel did not request that. They simply sat on this motion until the day of trial.
Well, let's assume that's true. Now we're at the day of trial, and there is going to be a hearing. Shouldn't it have gone to a different judge, at least under the practice in Hamilton County?
In this case, no. And the reason why is this is a backdrop, again, of COVID-19. This is a backdrop of a busy docket, and this is in the backdrop of the defense attorney, did not ask for it. In fact, the fact that she states, and opposing counsel states that this wasn't properly certified, just seems illogical, because the defendant in transcript document 58 files a motion, defendant's motion, in opposition to state certification of non-disclosure and request for hearing. So at this stage, it's incumbent on the defense attorney to make her motion in opposition. Her silence, her not asking for a continuance, her not having the opportunity to even speak with the 911 caller, and her silence throughout the entire trial and not even cross-examining this witness shows that she was not interested in speaking to witness.
Counsel, as defense counsel just pointed out, it would be really difficult to cross-examine somebody without any information about the person. So the fact that she didn't cross-examine, couldn't that simply be because she didn't have the opportunity to investigate the witness beforehand?
That's always a possibility, but there has to be an attempt to come up with an argument other than we didn't comply with 16 and hold this 7 days prior to trial, and that it wasn't held by a different judge. Again, I would ask the court, find us analogous to State v. Reed, when this honorable court in 1996 stated that the withholding of a witness's address, and this was a confidential informant, for no apparent reason, is what the court held. The state withheld that for no apparent reason. The court said they do not believe that foreknowledge of this address would have aided the appellant in preparation of their defense, or that he was unfairly prejudiced by the omission of this confidential informant's testimony. In this case, they were cross-examined. The opportunity was there and they availed themselves of it. And even after that, the court found no prejudice to the appellant, resulting from the prosecution's refusal to provide Thompson's address during discovery. They further hold the trial court did not abuse its discretion in permitting Thompson to testify. They did state, although we do not condone the prosecution's delay in responding to discovery request or this withholding, they found no prejudice. I would ask you to give deference to the trial court, to Judge Kissinger, where even if he made simply an error in law or judgment, it's not an abuse of discretion. And I do believe he made the proper order under the circumstances. He gave remedies. Those remedies were not pursued at all. The silence is really deafening on that issue from defense counsel at trial. I don't know if it was strategy. I don't know if it was a mistake, but she clearly was ready for trial, that day.
It sounds like what counsel's arguing for in this appeal is basically a per se reversal if the state violates discovery.
Correct. And we would ask that that would fly in the face of reason. And that would also fly in the face of the broad discretion over discovery matters that the trial court has. Because the other two issues presented for review have been effectively waived, I will rest on this unless.
Well, I'm not sure it's fair to say they've been waived. Counsel just chose to focus oral argument on the one issue. So
I apologize for that.
I don't think she's really, I don't mean to speak for her, but if you want to address those, now is the time to address them.
Thank you. I did not mean to misspeak in that manner. Secondly, the prosecution's remarks were innocuous. No prejudice resulted, even if they were improper. The ultimate issue for the jury was to determine who the driver was, not whether the officers were believable or unbelievable. They didn't see the crash. The ultimate issue, again, is fairness of the trial, not the prosecutor's culpability. You must look at the prejudicial effect in the context of the whole trial.
So again, you're focusing on prejudice, which I agree with you is, where we do need to focus. But are you arguing that the prosecutor's remarks were proper or that they were not proper?
They were proper, and they were proper in the context of chaotic scene. We have 5 witnesses who testified, 5 body-worn camera videos, 1 911 call, school buses zipping by. We have a garbage truck head-on collision with another vehicle, and both of the occupants were inebriated. The defendant was 0.187.
So calling the police amazing human beings is not expressing a personal belief or opinion as to the witness's credibility?
In this case, close to the water's edge, but no. The judge said, watch yourself, and admonished, but allowed the statement. So
how about saying that the officer's testimony was powerful? Isn't that giving an opinion about the credibility of a witness?
In this case, it actually cuts in the opposite direction for us.
But isn't it giving opinion about the credibility of the witness?
Not the credibility of the witness, but just the evidence that was presented. So the testimony is the evidence, not in how he spoke, not in his, and the prosecutor wasn't me. I was not stating that he himself was powerful, but just the testimony, the evidence was. And what was powerful was, well, first of all, the judge overruled the objection and allowed it in. But what was powerful was it cuts both ways. The defendant said to him on the way home, I took the charge for him, meaning the other guy, Anthony Hawley, her boyfriend. So in fact, that statement would have cut against the prosecution. But no, to answer your question, it's not vouching for the officer. It's merely talking about the evidence and the testimony. Again, it's all about context. If you read it verbatim in a vacuum, but not in context of the whole trial, you can pick apart certain things that don't fit that way. We would ask that the prosecutor be afforded wide latitude in those statements. And then even so, even if they were inappropriate, prejudice did not occur. The jury found all of the evidence. Well, they reviewed all of the evidence and they found the defendant guilty as the driver of the vehicle. On the third point, the jury did not lose its way in weighing the evidence. All of the state's witnesses except for one, that would be the sanitation truck driver, Jason Boyd, indicated at the scene that defendant was the driver. And at the trial, the only difference is Jason Boyd at trial said he was only 80% certain. At the scene, he said he's definitely the driver. The male is definitely the driver, but Mr. Boyd said he didn't see the crash. The 911 caller said she definitely saw a male figure by height and by running. There was definitely nothing feminine about him. She said, get out of the passenger side of the vehicle. When the police arrived, defendant is in the driver's seat of the vehicle. When fire arrives, the defendant tells Lieutenant Nienhaus she was the driver. As a patient, he's trying to assess her injuries. Multiple times, the police asked, who was driving? Are you sure you want to be the driver? Are you sure you're the one who was driving? These are serious charges. Only after she blew 187 on the ride home did she say, I took one for him, meaning I wasn't the one driving. It's very inconvenient or convenient for the defendant to change her mind after all of the evidence has been she's the driver. She had multiple chances to say she's not the driver. Multiple chances. In this case, the jury stayed the course and didn't lose its way. The evidence was overwhelming. It was undisputed that she was the driver. The only person that wasn't clear was the garbage truck driver, but he didn't see the driver. He just saw a man come over, and guess what he said? He said, why did you hit us? Could have said, why did you hit me?
Mr. Foreman, you are about at your time.
Oh, well, thank you very much for your time, Your Honors, Ms. Nelson. We would respectfully request that you affirm the jury's verdict and conviction. Thank you.
Ms. Nelson, you have your 5 minutes, but I'd like to start, if you don't mind, by asking two questions. One is the witness's address, who was not disclosed. She has a rather unusual name, does she not?
That's correct. I believe it's pronounced Schweibert.
And I guess I just go back to the prejudice prong. If nobody tried to call her when they had her number, or really even look her up with that unusual name to see if they could get some contact information, my first question is, what should we do with that? And then as a corollary to that, when I read through the transcripts, explain to me why there wouldn't have been a cross-examination about her ability to see, what she saw, what the lighting was, what the stature of the person was. I mean, there was silence on cross-examination of this witness, and some of it would have nothing to do with her background that you might find by interviewing her or doing a background search on her. So those are two things I'd like you to address.
With respect to the availability of the cell phone number, I would concede that cuts against the prejudice prong, and that is problematic for our claim. But I circle back to the fact that there still needs to be proper vetting of the basis for non-disclosure. Otherwise, like Judge Bach pointed out, the state will just say, oh, witness was afraid, we're not going to disclose information. And that is the harm that this case is trying to circumvent in future cases. To the extent as to why defense counsel didn't cross-examine the witness, I respectfully stand by my earlier remarks, is perhaps she just didn't have the proper tools, the investigatory tools to do that type of cross-examination based on the inability to investigate. I can't speak to why the trial strategy was to not and to cross-examine on the ability to observe. That is a good question, but I don't want to speculate for this court. But it is an interesting point, but I would stand by my earlier remarks, is that the lack of cross-examination was more of a reflection of the not being able to interview this witness at a time where, you know, her memory was as close to the event as possible, because that is what is most important when it comes to eyewitness investigation. I'd like to correct one statement that the prosecutor made in this case, which was that the defense counsel didn't request a disinterested judge. That was squarely requested in the motion in opposition, citing the case law that says that the 7-day hearing needs to be held by a disinterested judge. And to the extent that we're asking for a per se reversal, yeah, that's essentially what we're asking under the circumstances of this case, because the real harm in this case is that the withholding of the witness was due to an egregiously improper basis to withhold a witness from defense investigation. And that is the harm that we're trying to ask this court to circumvent in future cases.
But then the problem with that is that any discovery violation by the state, then it seems, would be a per se reversal. I mean, that's not the case law.
Sure. And again, I think this case, though, is distinguishable from the case law that would not reverse under situations where the name is disclosed, absent the address. But in those cases, the procedure was properly followed. So that's what makes this case unique. And it's harmful to Ms. Hall and her defense counsel not have the issue of non-disclosure properly vetted. It's harmful to her ability to have a fair trial. She's put between a rock and a hard place, having to move forward on the day of trial. Voir dire happened moments after this discussion was on the record. And you're making split-second decisions. I can't imagine what defense counsel could have done, other than maybe, like this court pointed out, taking the opportunity to investigate this witness. But at this point, the accident occurred almost a year prior. With respect to eyewitness identification information, that needs to be investigated close in time to the action, because memories fade. And I am not waiving argument on the second and third assignment of error, but I will submit on the arguments presented in my brief unless the court has any questions on those assignments. Okay, and if there are no other questions on the first, we respectfully request this court reverse and remand for a new trial.
Thank you. Any questions from the panel? All right, thank you both very much for your arguments. We will take this case under submission and give you a timely opinion. And Ms. Hayden, if you will bring our next counsel into the courtroom, please.
Thank you.
Good morning. The next case on our docket this morning is Gilman versus Fisna. Mr. Eberly is here on behalf of appellant. Mr. Redden is here on behalf of appellee. Mr. Eberly, you will have 15 minutes to argue this morning. Would you like to reserve any time for rebuttal?
Thank you, Your Honor. Yes, I'd like to reserve 5 minutes if that's okay.
All right, whenever you're ready.
Thank you, and thanks for taking your time this morning, everyone. My name is Dave Eberly. I represent the appellant and plaintiff Greg Gilman in this matter. This was a topic that the court reviews de novo. It comes on the heels of the trial court granting the defendant's motion for a judgment on the pleadings. a brief statement of the facts that are relevant to this case, and these are all gleaned from the complaint. My client, Greg, is a skilled software engineer and programmer. Fisna, the defendant and appellant, is a startup company, and it approached Greg a few years ago about hiring him for his expertise and services. That happened, but because Fisna was a startup company that didn't have a lot of cash, frankly, the agreement that was struck between the parties was that Greg would receive $1,500 a month, but with the opportunity, a very low amount of money, way below market for him, but that there would be the potential for a huge amount of money to come later should Fisna be one of those companies that proves profitable. So many startups don't. And so it was sort of a bit of a investment from both sides on that issue. Fisna wrote the contract to hire Greg for his services, and it made clear through that contract that Greg might not see these additional payments for some time. The plain language of the contract reveals this. That's important because there are only two arguments that the defendant appellee used in support of its motion for judgment on the pleadings. The first argument was that the language of the contract suggests if Greg is terminated, then these future payments are not payable. But the plain language of the contract says the opposite, in my view. The second argument they have, basically to support their motion at the trial court level, was that there was no profitability for the company at this time. It's clear, and the parties agree, that a condition precedent for Greg receiving these additional payments was profitability. Well, we alleged profitability in the complaint. We actually alleged that he met all the conditions precedent for him to receive these additional payments. Fisna, in its answer, denied that and attached to it and verified documents which suggest it doesn't have a profit, according to Fisna.
Counsel,
Yes.
if we were to find that the verified complaint was sufficient to show that Fisna had not achieved a profit, is this complaint premature?
You said if we find the verified, did you mean the answer?
Yes, I'm sorry.
No,
the verified answer.
That's fine. Yeah. So you're right. I think that's the right frame of mind to be on this, which is that what the trial court really did here was kind of grant a motion for a summary judgment without calling it that. The answer had a verified document sworn under oath attached to it. Now, that's what you might see in a Rule 56 motion, a motion for summary judgment. And if that is what the court was thinking, this is verified, and therefore it's akin to a sworn statement, that's enough, then what the court needed to do was inform the parties that it was considering this motion for judgment on the pleadings as a Rule 56 motion, but allow the parties to either entertain a similar response through a counter affidavit or a response through developing a record through discovery. There's good Ohio case law that says if you're going to convert a motion to dismiss into a motion for summary judgment or a motion for judgment on the pleadings into a motion for summary judgment, you have to provide a notice to the parties to do that. The court didn't do that and didn't even really hint that that's where he was going with this. So I'm kind of extrapolating a decision that we don't have the insight for the trial court judge. But I think that your question, yes.
Was there any request, and I'm not suggesting that you needed to do this, but was there any kind of a 56F motion, even though it wasn't a motion for summary judgment, to say, hey, we need to test these financial statements. We need to get the work papers that support them, to cross-examine. It said they were audited financial statements. I'm not sure that's correct. Who was the auditor?
Right. I don't know that you're right, Judge. First of all, to answer your question, there was no specific 56F request. I can say I would have made one if the court said, I'm considering this a Rule 56 motion. I'm sorry, I'm making eye contact with your faces on my other screen, not the camera. It's confusing, I know, but you're looking at the side of my head.
We're used to that. We will do the same thing. So
I'm not savvy enough to look into the camera. But right, we would have gone through discovery, Judge, to verify whether Fisna was lying under oath about that, or whether the statements have backup to support the financials that they supplied, or whether Fisna was acting in good faith in calculating profit. which I could anticipate would be a battle at trial. You know, how does one, I think Amazon doesn't show a profit right now. And so there's lots of ways to have challenged and attacked or at least probed into the veracity of the answer for what the court did.
Were those statements just showing that there was no profit while your client was employed?
That was a focus that the trial court, the same question was asked by the trial court, was does it matter whether, does it matter whether the profit was earned now or later? And the contract is not the best written contract. Opposing counsel is excellent. I'm sure he didn't write this contract, but when Fisna wrote the contract anticipates that the profit could be realized many years into the future. It calls for interest payments to flow later on. It calls
so even after he's terminated, if they became profitable after termination, your argument is he still should get the additional compensation.
That's reading the contract in total. That is clear intent of the parties. And I can point to some language in the contract. The contract says termination shall not result in the loss of the developer's right to receive the payments for work provided up to that date. So he can't say that I should get money for work that I didn't do. That's not what we're saying. It's for work that he did, but that the profits that are to be realized in the future would warrant the bonus for. And that makes sense because Greg knew this wasn't going to be profitable in year 1 or 2. You know, the contract goes off and says that maybe it'll be 5 years before we see a profit, and anticipates interest on some of these payments if it's not for 5 years before a profit hits. And so the argument that they made that once we terminate the contract, that cuts off future payments, the opposite's true for the contract. What it does, it cuts off your ability to come to work the next day and make money for those hours that you worked.
But the complaint, where in the complaint do you allege that Fisna actually made a profit at all?
Yeah, so I don't know if we actually said that in the complaint, but we did say that we met all conditions precedent to reap these balloon payments, including profitability. And so I don't think we said it. I went back and looked at that, but I probably should have been explicit about that, but we, for notice pleading standards, certainly did that. And that was not something that the trial court was concerned about, nor was it something that counsel raised in his argument that we didn't allege profitability. The opposite was true. It was that we have a disputed fact about profitability, but ours should win because it's verified under oath, and yours isn't. Well, okay, that's fair, but that's a Rule 56F motion, or Rule 56 motion, not a Rule 12 motion at that point in time. That's the argument we're making. It certainly could be that Mr. Redden's client prevails at trial and shows there wasn't natural profitability. We just never got that far. So, yeah.
And you have about 1 minute left.
Yeah, well, thank you, Judge. It's akin, I appreciate you guys having read this because it just makes the oral argument easier, obviously. But the analogy, and I can only think in analogies because I'm not the brightest person in the world, but the analogy I always think of is a car wreck case where the plaintiff alleges that the defendant behind him failed to stop in time. And the defendant said, oh, it wasn't my fault. The light was green, or it's just the sky was blue or the sky was red. And the court chose to do the opposite of what the civil rules obligate it to do. It chose to believe the answer at the motion to dismiss / motion for judgment at the pleading stage, rather than believe the complaint. And that's the essential flaw with its decision. Thank you. Any further questions in my 30 seconds left? Okay.
Thank you, Mr. Eberly. Mr. Redden?
Good morning, Your Honor. Just may it please the court, Mr. Eberly. Fisna was successful on its motion for judgment on the pleadings because the plaintiff in this matter, Greg Gilman, cannot, as a matter of law and as a matter of fact, as established by the pleadings, demonstrate he is entitled to any relief that he asserted in his complaint.
Ms. Redden, let me interrupt you early on.
Yes.
And ask you maybe sort of the corollary of what I asked Mr. Eberly.
Certainly.
To accept the argument that you just made, don't we have to look to something outside the complaint that's attached to the answer, which is and I don't know if they're audited or not because I couldn't tell, but the allegedly audited financial statements that you attached, and doesn't that take it out of Rule 12?
Not at all, Your Honor. Not at all. And the trial court did the right thing here by granting judgment on the pleadings because the material facts with respect to this case, as evidenced in the underlying agreement, as well as the sworn audited financials, are undisputed. No amount of discovery, no amount of deposition, no amount of testing.
Mr. Redden,
Alter that.
Mr. Redden, what usually can be attached to a pleading for consideration under Rule 12 are contracts, deeds, leases, and other documents that evidence the rights and obligations of the parties. That's what the case law says here. I don't see how financial statements, can you explain how financial statements that didn't exist before the complaint was filed, how does that fit in?
Well, first of all, Your Honor, those documents did exist before the complaint was filed, number one. Number two, because it did come up, the financial statements that were attached were for fiscal years 2017, 2018, and 2019, which was beyond the term that Mr. Gilman was with Fisna. So that's part one. Part two is those financial statements feed into and are what ultimately generate the tax returns of the entities, which would also demonstrate the same issue. So,
but aren't they entitled to discover all of that and to probe on it? I mean, isn't that what discovery is about?
well, discovery is about probing, about testing. However, unnecessary discovery obligations of a party should not be undertaken when no amount of discovery, no amount of deposition, no amount of discovery and analysis is ever going to change an immutable fact.
Well, let me challenge you on that. Let's say hypothetically, and I don't know who the auditor was on these statements. Let's say it's PwC, a nationally recognized accounting firm. If I were an astute plaintiff's counsel, couldn't I probe those audited financials by cross-examining the expert and saying, did management tell you this? Did management tell you that? Did you test this? Did you test that? And even in a case where a nationally recognized firm was the auditor, I might be able to chip away at the veracity of those statements. And aren't I entitled to do that?
Again, if the answers are ultimately going to be the same as they are, these are verified, attested to, sworn statements from the company, from the representatives.
Well, you said they were audited financial statements. Who was the auditor? I couldn't tell that from the documents.
It's the company CPA.
Well, then they're not okay, an outside, and they were actually
outside CPA.
They were audited and not just reviewed.
Correct. That's right. And ultimately, again, you're going to get Mr. Eberly, who we have had cases over the years. He's very competent, very astute counsel. Certainly, he would go after that question and would investigate it, just like Your Honor would have back when you were involved in litigation. And ultimately, Mr. Eberly is going to get the same answer there that he gets now, which is the outcome that was attested to and verified by the company that led to the conclusion here. So
I'm going to press you a little bit more on that. How is he to know that without any discovery? I mean, how does he know that the outcome will be the same without any sort of discovery?
Well, and I should be maybe a little more careful in the use of the word outcome. The answer will be the same, which is there was no net profit generated for the entity during that time. It's simple math, really. I mean, I understand the ask of the question, but ultimately the outcome is identical to what it was in the verified answer and what it was before the trial court, which is the simple math of the financial statements, the simple math of the performance is that the company has not realized net profit in order to cause even if there were an obligation, which we don't believe there was, because the language of the contract is actually clear to the contrary, that this is not a continuing obligation or the continuing potential for the creation of additional compensation after termination, unlike other terms of the agreement provided for continuing obligations after termination of the agreement. So
on that subject, counsel,
yes.
On pages 11 to 12 of your brief, you say that section E of the agreement expressly conditions any obligation to pay the net profit payment upon Fisna actually making a profit during the term of the agreement. Can you tell me the precise language in that clause that backs that up?
The precise language in section D.
Yeah, because you said that it expressly conditions obligations to pay on Fisna making a profit during the term of the agreement.
The total due to developer by way of net profit is limited to and contingent upon the company achieving net profit. Period.
It doesn't say during the time that he's employed there.
Then section E directly below says the company or the developer may terminate this agreement at any time. Again, this was an independent contractor agreement that allowed the parties to exit the relationship, essentially, which is customary in the technology field, to allow either the company or a software engineer to exit the agreement when they choose to move on. And
but it also, that
Fisna
same
did.
clause also says that termination shall not result in a loss of the developer's right to receive payments for work provided up to the termination date.
that's right. That's right. So what Mr. Gilman does not lose is if Fisna achieves profit during the time that he was engaged under the independent contractor agreement, he doesn't lose the right to those payments in the future. As a matter of fact, what the agreement provided was Fisna wasn't going to have to pay Mr. Gilman in one large lump sum should that condition precedent be fulfilled. The issue here was during the time that he was in the contract prior to contract termination, Fisna had not achieved a net profit. And because Fisna had not achieved a net profit during the time that he was engaged, that obligation wasn't created. Therefore, what you get into, as instructed from the first district precedent in the Wiper case, as well as the Ninth Circuit decision in Chicago West Pullman, is clear that obligations that do not arise during the term of the engagement don't exist in perpetuity. Under the argument that Mr. Gilman is putting forth and the argument that is put forth on his behalf this morning, essentially what is created is an opportunity in perpetuity for Mr. Gilman to gain a windfall from work that he did or work that he never did. And that's clearly not what the contract contemplates. And the fact of the matter is, I mean, he was terminated by Fisna because he wasn't performing. He was terminated by Fisna because he didn't satisfy the basic requirements.
Is that relevant though?
Beyond the context of it, no. The fact of the matter is Mr. Gilman was terminated. And this was part of the verified answer. He was terminated. He was notified of his termination, and he was made whole on work that he had done to that date with a notation on the check that it was full and final payment that he endorsed, accepted, and cashed. So Mr. Gilman was well aware that Fisna's position since sometime in 2018 was that he had been fully and fairly paid. And he made no objection to that until he saw an article that in the newspaper that then spurred this opportunistic litigation.
Just to understand your bottom line argument in this case is that the attached financial statements, the audited financial statements, are written instruments under Civil Rule 10C. I mean,
Absolutely.
Okay.
Absolutely, positively. And Judge Krause, I wanted to follow up on one question that you asked of Mr. Eberly, because I think it is particularly insightful, and I think it's cogent to this case. And that, was Mr. Gilman's complaint premature if you find that the verified answer demonstrates through the attachments, which I think is proper to do, obviously under 12C, that the plaintiff's complaint was filed too early, putting aside the other contract interpretation issues, which I think are likewise in Fisna's favor. But certainly, I think at a very basic level, assuming everything else, which I don't, but assuming everything else that Mr. Gilman asserts is true, he filed his complaint too early, and that's what the financial statements show. He's essentially filed for an advisory opinion from the court that he's entitled to some money at some point in the future. Again, we don't know when, because the import of the argument of the plaintiff is that this opportunity for him to earn more money exists in perpetuity.
Let me probe you, Mr. Red, and I just pulled up Rule 10. But show me the language of Rule 10 that you say these financial statements fall under.
Well, they are part of their, effectively, they have to be incorporated into the agreement, because the agreement says that whether Mr. Gilman earns the additional net profit compensation requires that there be a net profit. Therefore, you need to look at the net profit calculation.
Well,
But
what if the way to do that, what if they aren't audited financial statements? What if it's just the company saying, hey, we never made a net profit, I'm attaching an affidavit, here's our profit and loss statement for the year? I mean, that's not sufficient, is it? Because that's what discovery is entitled to do, is to probe those numbers.
Under Rule 10, first of all, I think in theory, you're right about the discovery, Judge Myers. However, what I would say is attachments to pleadings include accounts or written instruments that.
This isn't well,
it's a written instrument of the entity, verified by the entity as truthful and accurate. And
so any piece of paper that I verify as true and accurate becomes a written instrument?
Well, it's a written instrument that existed prior to the assertion of the claim that goes to whether there is actually a claim or not.
But I have a letter from somebody that existed prior to the claim, and I verified that I received the letter and that it's accurate. That doesn't turn it into. It could.
Oh, no, absolutely. I think it could. If it's a letter from a plaintiff in a breach of contract case that says, I understand everything has gone smoothly here and there's no issues, I would certainly attach that to an answer if I was defending an entity in that case. If it's
do you have any case law? And again, I'm going back to what I said before, that the case law says that written instruments include contracts, deeds, leases, or other documents that evidence the rights and the obligations of the parties. How do these financial statements fit into that?
Because they are documents that evidence the rights and obligations of the parties. They supplement the critical document here. You can't consider the independent contractor agreement without considering the financial statements that are part and parcel of whether the condition precedent has been satisfied or not. And the fact of the matter here is that Mr. Gilman can't satisfy the condition precedent for the creation of the obligation that existed during the term of the agreement. And because he can't satisfy the condition precedent that existed at the time that the agreement was in force, he has no breach of contract claim. He has no unjust enrichment claim because there is a written agreement, and there is no breach of the implied duty of good faith and fair dealing because the underlying breach of contract claim doesn't exist because the condition precedent was never satisfied. In addition, there's no express survival language as required with respect to the net profit payment calculation. There were continuing obligations with respect to trade secrets and confidential information. There were continuing obligations with respect to non-competition. There were no express survival language within the agreement with respect to the creation of an obligation with respect to the net profit payment. There is.
Mr. Redden, you are at your time, but I will let you finish that thought, and then if the panel has any other questions.
Thank you, Your Honor. Your Honor, for the reasons we've discussed, the trial court properly granted Fisna's motion for judgment on the pleadings. The evidence before the court, the information before the trial court was a sworn verified answer with appropriate attachments, and it demonstrated that Fisna had not made a net profit at the time the complaint was filed. And indeed, that Fisna had not made a net profit during the entire term of Mr. Gilman's agreement. As such, under no circumstances would Mr. Gilman be able to prove he's entitled to such payment under the plain language of the agreement that is contingent upon Fisna having such an event. Based on the foregoing, we ask that the court affirm the decision of the trial court and that this matter be concluded. Thank you.
Thank you, Mr. Redden. Mr. Eberly, you have 5 minutes remaining.
Thank you, and thank you, counsel, and thank you to the court. What Mr. Redden just said, it was essentially the problem with this decision by the trial court. He believes, and I believe him that he believes this, that we can't win our case ultimately, but it's not up to us to trust the defendant to say that we can't win the case ultimately because there's no profit. And Judge Bach, your question about, is this a proper Civil Rule 10 attachment, I think one that echoed by Judge Myers, gets to the heart of the problem here. Because if this is a proper Rule 10 attachment, then the barn door is wide open to let every single answer be verified with some sort of attachment that can't be probed, challenged, or tested through discovery. It just blurs the line between a Rule 12C motion and a Rule 56 motion, which is why the Rule 10 limits what you can attach to a pleading so clearly. This is not an account or a written instrument that dictates the party's rights. The contract is, that was attached. More than fine to do that. This is evidence about the case that's being attached here. And that's the problem I had with it. To the other issue about termination, I think I might be crazy, but I don't know how this sentence isn't exactly the clause that opposing counsel criticized is not in the contract. Very explicit that this shall survive termination, his ability to accept these future net profit payments. Termination shall not result in the loss of the developer's right to receive the payments for work provided up to said date as laid out herein. That clause can have no other meaning than to say to Greg Gilman, if you get terminated, we haven't realized these profits yet, don't worry, you'll get credit for the work you performed with respect to those profits, X dollars a month. You're not going to get X dollars a month forever. Once you're fired, you don't get credit for those months, but you get the credit for what you did and the potential net profit payment before. Otherwise, all Fisna would have to do is to fire him, which it can at will for any reason, immediately before it expects to hit net profits. That would be the way to get out of this. And that's not what the parties bargained for and what Mr. Gilman bargained for. And if you read that sentence again, there is no other reason to have that clause in the contract. It's essentially saying, if you were reading it as Fisna is asking the court to read it, that don't worry, Greg Gilman, we put a sentence in your contract that says we can't go back after you for the money you made after we fired you. That makes no sense at all. No employer or no company hiring someone else can say, oh yeah, we need to put this in writing. We're not going to get back payment to you for the work you perform. That's a nonsensical statement unless it means that the obligations to pay based on these profits going forward will survive a termination of the contract. So that's the only 2 points I wanted to make. Do you have any questions for me, anyone on the panel?
Any questions? Thank you both for your arguments this morning. We will take the case under submission, give you a timely opinion.
Thank you, Your Honor.
Thank you, everyone. Thanks.
If you will bring our next counsel into the courtroom. And if I can say to my colleagues, I have been going in and out a little bit here with my internet. If I freeze up, I still can hear you, but I'm going to ask if Judge Krause will take over if I appear to be frozen at any point in time. So thank you. I think it hasn't been a problem, but I just got a little note that my internet is unstable. And I know a few times that I have frozen or you have frozen. So thank you. Thank you all. Sorry about that. Our next and final case to be argued today is In Re AG. Ms. Moss is here on behalf of appellant. Ms. Steer is here on behalf of appellee. Ms. Moss, you will have 15 minutes to argue this morning. Would you like to reserve any of that 15 minutes for rebuttal?
Yes, Your Honor, I'd like to reserve 3 minutes.
All right, and I will keep your time whenever you're ready.
Good morning, Your Honors. Ms. Tier, may it please the court. My name is Jessica Moss, and I represent the appellant AG in this matter. This case concerns unreliable in-court identification, which is connected to the analysis of all of the assignments of error, as well as a charge of complicity to robbery without any connection between AG and the person who actually committed the robbery against Schreiber. As to the first assignment of error, the in-court identification was not reliable. And primarily, this is a reliability issue. To be clear, we're not challenging that the photo array was unduly suggestive, but rather it was this in-court identification, which was not based on independent observation and recollection that was not reliable.
Is this really a manifest weight argument then?
So it goes into the manifest weight argument, but because the analysis is different in terms of the factors in Neal v. Fair, as well as the fact that this goes into all of the assignments of error, I set it out in a separate assignment of error.
But is it a argument that it was inadmissible? Is that your argument? Or that the judge improperly relied on it in making her guilty finding?
Essentially, it's both. Initially, the fact that the in-court identification itself is not reliable, and looking at the fact that there wasn't independent recollection observation when we have this witness saying he doesn't remember any of the details regarding person one that was seen at the library. It was only a trial about this issue with these eyebrows that was not brought up before. But even if it is an admissibility issue, it goes to the weight and credibility of this identification. So even after this identification was made, it was clear through the testimony of Schreiber that this cannot be relied upon.
Ms. Moss, let me ask you a question about the admissibility piece of your argument, because how should we consider the following? When the victim did ID your client in court, and the state said, may the record reflect identification of the defendant, and the court said, is there any objection? Counsel said, no objection to the in-court identification. Isn't that an explicit waiver of any argument that it was inadmissible if there's no objection?
So, Your Honor, it wasn't to the initial identification. Defense counsel expected Schreiber to say that he was only 40% confident like he did in the photo array, but it was Schreiber's testimony after that identification, which was what the basis for trial counsel's objection and argument to this was. And so in the criminal rule 29 motion on in closing and on objection, defense counsel then went through all of those analysis in terms of the unreliability of this in-court identification, the fact that the court shouldn't have relied on it.
Doesn't that go to Judge Krause's issue? Doesn't that go to weight and sufficiency and not admissibility?
More of this issue goes to weight and sufficiency, yes, but it also goes into this other issue about the second assignment of error in terms of the Facebook photos and messages being admitted. And so again, that's why I did this as its own assignment of error. Here, in looking at the factors in Neal v. Biggers, all of those show that this in-court identification was not reliable under a totality of the circumstances. First, Schreiber had minimal opportunity to view person one at the library. He only momentarily viewed that person. And he as to the second factor, he could not even remember if he made eye contact with person one. Now, as to the accuracy of the description, Schreiber could not describe anything about person one, not even the height, build, clothing, hairstyle, or even whether or not this person was wearing a hat. And that's much different than the description that Schreiber is able to give for person two, the person that actually committed the robbery. Now, the level of confidence, again, Schreiber is only 40% certain that AG was the same person that was in the Drew Scheme Facebook profile, as well as the person at the library, and said that there was a photo or two he recognized. Now, although Schreiber said that he was 99% confident at trial, that does not weigh in favor of this ID being reliable, because Schreiber is saying that when there were 6 photos, it made it hard to identify a person versus having just one person before him in court. And that's precisely what the concern is with having an in-court identification where you only have one person before a witness in court. This person only has that person to identify. And the length of time from the incident to the in-court identification was over a year. And Schreiber even said that his memory would have been better closer to the time of the incident. Now, this case is distinguishable from State v. Sheldon in that even though that was looked at under a plain error analysis, there was other overwhelming evidence of the defendant's guilt. And that is not the case here. But for the court's reliance on this in-court identification, the outcome in this case would have been different. And that goes
there was the information on the Facebook printout. There was a photograph, right?
Yes.
Of whoever that was. And in addition to the victim pointing to your client in court, didn't the magistrate judge also say that the Facebook photograph resembled your client?
I don't believe that the judge said it resembled. It was solely based on the fact that, well, initially the judge said that, and the court said that initially there was no indication that AG was the one who owned, operated that account, or was the one to message Schreiber, but it was only because of this allegedly seeing AG at the library that the court then found this to be a message sent by AG. But I don't believe the court ever specifically said it looked like AG. Now, there was also in those photos that were on Facebook, also several other individuals in those photos. It wasn't just photos of one person in what was admitted.
She said the state's photograph exhibits corroborate that the juvenile looked identical at trial to the current pictures on the Drew Scheme account. So it looked like she was just looking at the Facebook photo and comparing it to your client at trial as well.
I apologize, and I misspoke. There was a situation as well where the court then looked at this hair and trying to give some explanation as to why Schreiber's identification would have been different in the photo array versus at trial. The problem is Schreiber couldn't even say whether he saw this person's haircut. And even in the photos, there are several different people. Some have a hat on, some don't. And there's a variety in those. But the court basing some identification being on what Schreiber said the person looked like in person, there was nothing that Schreiber could base that off of other than later saying it was eyebrows. Problem is that there was never any indication that AG's eyebrows resembled what Schreiber was referring to, or even whether the eyebrows resembled what was in the Facebook photos. And just briefly, in terms of the second assignment of error, the other issue with the text message exchange was the court admitting this for one purpose in terms of just using Schreiber's statements, and then at the end of trial saying that the court was admitting both Schreiber's statements as well as the statements coming from whoever was on the other end of the Drew Scheme account. Now, this differs from a lot of the other cases in terms of whether or not Facebook can be identified, because here Schreiber was not friends with AG, was not friends with Drew Scheme, and there was no other prior in-person or online relationship between the two. The only interaction between the Drew Scheme account and Schreiber was for the sale of the phones that day.
How would the Facebook, in your opinion, the screenshots be properly authenticated?
So while in terms of the actual photos that came in, it's not that these are the photos that were coming in as whoever messaged Schreiber, but it's the fact that they determined that these actually were an account operated by AG, and therefore he sent the message. And that was the problem with not only the messages, but also the photos themselves.
So what would the prosecution need to do, in your opinion, to properly authenticate these? What should they have done?
So there needed to be some other information establishing somebody, knew AG, operated this account, or had a friendship with him, that he was the one who would have communicated under that, to show that it wasn't somebody else who put some photos on there, but had no connection to AG himself.
Doesn't that go more to weight than to authentication?
So it goes to both. But initially, in terms of the Facebook screenshots and photos, there has to be some initial basis of authenticity that it is what the proponent says it is. That is, that it's coming from AG, which didn't happen here.
Well, it is what it purports to be. It's a screenshot coming from the Drew Skeens account. Whether
Yes.
it's AG goes to weight and sufficiency. I think
The court I'm sorry, Your Honor.
Go ahead.
Unfortunately, the court, in admitting these messages and screenshots, said that it was AG specifically, and it was admitting it for that purpose, and that's what they said at the end trial, and that's where we take issue with how the court admitted these. As to the third assignment of error, third and fourth assignment of error, there's no connection between AG and person 2, let alone that AG shared the intent of person 2. So even if, let's say, AG was person 1 that was there, person 1 was walking towards a library where the sale of the phones was supposed to happen. There was no evidence that person 1 was in eyesight or could see what was happening with person 2 assaulting Schreiber and taking the phones. There was no communication between person 1 and person 2 afterwards, showing that they've ever talked together or were conspiring together to come up with this plan. And that's really what's missing here. You would expect on this type of a case that the police would have had some other evidence connecting AG to person 2, and there's no evidence of that. There's no evidence of,
You have about 1 minute left.
yes, there's no evidence of any criminal intent from what's in the Facebook messages other than for a sale of the phones. So even if AG was person 1, and even if AG was the person who was at the library that day, it didn't mean that AG had the intent for the phones to be taken and for Schreiber to be assaulted.
Isn't that, though, taking everything in the light most favorable to the prosecution, an appropriate inference that AG arranged this meeting?
Even taking the evidence in like most favorable to state, there still has to be something more, and that's what's missing now. It's not as if AG and person 2 or even person 1 and person 2 were seen afterwards to connect them together after these phones were taken. So our argument is that there would have to be more. As to
You are at your time if you want to reserve 3 minutes.
Yes, sir. I'm going to briefly just go to the fourth assignment of error. As to Schreiber's statement that he said that he saw person 1 that he believed to be AG, that doesn't comport with what his testimony was. If he saw the person he believed was coming to buy the phones, then he would have stopped and asked that person if they were there, especially since this was only a few minutes after the sale of the phones wasn't happening. It wasn't, again, Schreiber was walking away from the library, and there was no testimony about what person that was on the Drew Scheme account knew about the what Schreiber looked like to know to stop him. And if there are no other questions, then I'll reserve the remainder of my time.
All right, you will have 2 minutes remaining. Ms. Steer, you have 15 minutes.
Good morning, Your Honor. Counsel, may it please the court. Let me touch on the first 2 assignments of error as far as they go to the admissibility of the evidence, and then I'll discuss the reliability, which I do agree is a matter of the weight that was given it by the magistrate. With respect to the first assignment of error and it's limited only to Schreiber's in-court identification of AG. And there was no objection, Judge Myers, as you read. The defense counsel clearly and explicitly waived any objection to the in-court identification. And in fact, when you read the objections that trial counsel filed to the magistrate's decision, he even makes a distinction, even though he talks about Niels versus Biggers, he says, even though this is usually part of suppression, he's just talking about it as far as reliability. He was not objecting to the admissibility of the in-court identification. Even if there were some objection to it, or if you reviewed it under plain error, as I say in my brief, first you have to look at whether or not there's any improper misconduct on the behalf of the police. And as this court just recently said in Stidham, even in court identifications, you look for whether or not there's any improper conduct. And here there was none. They just had him identify him at the table. As far as I'll talk about the Biggers reliability when I'm talking about the weight and whether or not the identification was reliable. So if I could jump to the second assignment of error with respect to the authentication of the Facebook screenshots, all that was necessary was for Schreiber to say they were what he said they were. He said before he went to do the sale of these two phones, he was going to go to the Madisonville Library. Before he went, he took screenshots of the phones, he took videos of the phones, and then he took screenshots of the messages that he was using back and forth on Facebook Marketplace, and he took pictures or screenshots of the Facebook page with the person that he was going to do the sale. That's all we needed for authentication, was for him to say that they were what he said they were. Then the burden would shift over to the defendant to challenge whether or not they were, or to show that they weren't what they said they were. And that wasn't done here. There was really no challenge to the authentication, short of making the objection, but really the objection went to whether or not they were reliable and what they could be used for to show in the evidence. So really, I think all of this boils down to the reliability of the evidence, and really it goes to weight. As far as the sufficiency and weight, the state put on evidence that AG arranged a sale with Schreiber. And like the magistrate said, the evidence was that 3 people knew of the sale. She found that because the phones were tucked under Mr. Schreiber's arm, that it was unlikely that anyone else would have known they were there to look for them. So it had to have been someone who knew about the sale. And she found that given the screenshots of the person and how they matched the description of AG, that he was involved and that he was complicit in the robbery. As far as the weight of the evidence and the trial court relying on the identification, it's true that I think Mr. Schreiber, during his testimony, they kept asking him whether or not what he had told the police investigator, and he really couldn't remember what he had said. But when you look at what happened, he had pictures of the person who he was supposed to do the sale with. He had pictures of the person that he recognized as person number 1, the person who passed him, because he recognized him, he looked him right in the eyes. So really, it would seem odd, I think, that he would give further description of a guy when he had pictures of the person that he could hand the police detective.
Can you explain at all why he didn't stop the person? I mean, he said he recognized him from the Facebook post, like what, and the guy passes him and he looks at him. Why didn't he say, hey, are you here to buy the phones? Was that
I'm not sure. I think he started getting nervous. I don't know. He did not explain why. He did not. But on the other hand, if you accept that AG was there based on his description, and if we're saying then, well, he was just there for the sale and all he was doing was walking to the library to consummate the sale, AG didn't say anything either to him. So that kind of
Did AG know what the victim looked like?
Did AG know what the victim looked like? I am not certain. That wasn't in the evidence because
Okay,
obviously
so-
he didn't testify.
So it's not as odd that AG would have walked by without saying anything.
Well, I'm not sure how you would go to buy. I've never done any of these like sales of online stuff, but I don't know how you would go to buy something without knowing what the person looked like that you were going to do a sale with. So I know it's an assumption, but I'm assuming that he would know who he was supposed to be meeting. I don't know if he went to the.
Well, he's arguing he wasn't there at all, right? Isn't that what AG is saying?
He is, but
That wasn't him?
I think that they're kind of as an alternate argument. I think they say even if he was there, he was just there to consummate the sale, and all.
Oh.
If you can explain his presence there, I do think that in the within their argument about weight and sufficiency, I think they did say that there was no evidence that he was present at the scene, and clearly that's not accurate because Schreiber placed him there. Schreiber identified him there. And as far as any of the other standards for reliability and how he changed from saying he was 40% sure to 99% sure, he did explain that the hairstyle was different, and I think the magistrate credited that. The magistrate was there to listen to the cross-examination of Schreiber, and that's exactly what's supposed to happen. This court in Stidham, when they were talking about the reliability of in-court identifications, they said most of reliability, if there's no misconduct, most of reliability is challenged through the adversarial process, and that's what happened here. He was questioned extensively about why he believed he was 99% certain. The magistrate was in the position to judge his determination, and she concluded that he was credible. Unless there are any other questions, I'll rest on my brief, and we'd ask that his adjudication be affirmed.
Any other questions for Ms. Steer?
Thank you.
Ms. Moss, you have 2 minutes remaining.
Thank you, Your Honor. Your Honor, in regard to whether or not Schreiber was able to provide any other information regarding person one, you would expect that, and that's what's required in terms of looking at the reliability of making identification, that there's independent observation and recollection, not just having some photos from Facebook. You have to actually say whether or not this is the person. And really, in walking by, he doesn't remember if he made eye contact with this person and momentarily looked at this person. Of course, he's not going to remember these other things, which makes this in-court identification even less credible, especially when at first he was only 40% sure it was AG matched the same person and recognized a photo or two. Now, we are arguing that AG was not there, but alternatively, even if he was there, and Judge Krause is correct in that AG was walking towards the library if AG was in fact there. But the notion that this court is looking at the hairstyle being different to explain certainly doesn't make sense if Schreiber cannot describe the hairstyle. Additionally, the court looked at the fact that at first they didn't believe that it was AG who operated or sent this message, and it all boiled back down to this identification. And only because of the court looking at identification, the court then tried connecting all the dots. But it's too much to say that just because AG's picture appeared on this Facebook profile, as well as somebody who, in regard to this unreliable identification of AG allegedly being at the library, that AG was complicit with this person too, who committed the robbery, in terms of coming up with a plan to commit the robbery and in having this assault against Schreiber. For all of these reasons, we ask that this court reverse the juvenile court's decision because there is not enough to adjudicate AG of complicity to robbery. Thank you.
Thank you. Any questions from the panel? Ms. Moss, Ms. Steer, thank you very much for your arguments this morning. We will take the matter under submission and give you a timely opinion. That will conclude arguments this morning for the First District